Good evening, attorney. Good evening, classmates. I am Carlito Jr. From Group 1. I am tasked to report Section 95 of the RCCP regarding closed corporations. I have to share my screen. Okay, closed corporations. What is this closed corporations? In Section 95, it defines a closed corporations. It states that a closed corporation within the meaning of this code is one whose articles of incorporations provides that A. All the corporations issued stock of all classes, exclusive of, of treasury shares, shall be held of record by not more than a specified number of persons, not exceeding 20, and B. All the issued stock of all classes shall be subject to one or more specified restrictions on transfer permitted by this title. Letter C. The corporation shall not list in any stock exchange or make any public offering of its stocks of any class, notwithstanding the foregoing. A corporation shall not be deemed a closed corporation when at least two-thirds of its voting stock or voting rights is owned or controlled by another corporation which is not a closed corporation within the meaning of this code. Any corporation may be incorporated as a closed corporation except mining or oil companies, stock exchange, banks, insurance companies, public utilities, educational institutions, and corporations declared to be vested with public interest in accordance with the provisions of this code. The provisions of this title shall primarily govern those corporations provided that other titles in this code shall apply suppletorily except as otherwise provided under this title. Okay, we will proceed with the next slide. Those are corporation requisites mentioned in Section 25. Those requisites must be expressly stated in the Articles of Incorporations to be considered as a closed corporation. Otherwise, it is not a closed corporation. It is an ordinary corporation. We should remember the requisites. Number one, as to the number of persons, it should not be exceeding 20. And number two requisites, the issued stocks of all classes shall be subject to one or more specified restrictions. And number three requisites, the corporation shall not list in any stocks exchange or the corporation is prohibited to make any public offering of its stocks. So those are the requisites of the closed corporations. What are those examples of closed corporations? Any corporation may be incorporated as a closed corporation except number one is mining or oil companies, two is stock exchange, banks, insurance companies, public utilities, educational institutions, and corporations declared to be vested with public interest in accordance with the provisions of this code, or a corporation wherein at least two-thirds of its voting stock or voting rights is owned by another corporation that is not a closed corporation. So all corporations may be incorporated as a closed corporation except for those corporations I have mentioned earlier. and those corporations vested with public interests, and also those corporations wherein at least two-thirds of its voting stock or voting right is owned by another corporations which is not a closed corporations. Okay, we will proceed with the next slide. What are the differences between a closed corporations and ordinary corporation? A closed corporation, number one difference is there is a limitation on the number of stockholders to a maximum of 20. That was I have mentioned earlier. And while in ordinary corporation, there is no limit as to number of shareholders. And number two difference, there must be in closed corporation, there must be a restriction on the transfer of shares. In ordinary corporation, a restriction on the transfer of shares need not to be provided for. And in closed corporation, number three difference, specific qualification to be eligible as stockholders are usually provided for, while in ordinary corporation, qualifications of stockholders are not normally prescribed. In closed corporation, public offering of share is prohibited, while in ordinary corporation, public offering of shares is not prohibited. Number five difference, may be managed directly by the stockholders in a closed corporation, while in ordinary corporation, managed by the board of directors, not by the stockholders. And number six difference, in a closed corporation, there are rules on deadlock, while in ordinary corporation, there are no rules on deadlock. And last difference, number seven, in closed corporation, a shareholder may withdraw and may ask the corporation to purchase his share, while in ordinary corporation, generally, the shareholder cannot withdraw and compel the corporation to purchase his share except as provided in Section 40 of the RCCP. So going back with number 6 and number 7, I have to explain just a little bit. What are this deadlock means? What do you mean by deadlock? Deadlock means that there is a situation, typically one involving opposing parties, usually the stockholders or the board of directors, wherein the votes required for any corporate actions cannot be obtained, in which case there is no progress that can be made. So there are two opposing parties, usually involving a board of directors, wherein there is a votes required, but it could not be obtained because the votes cannot be obtained because of these two opposing parties. So in which case there is no progress that can be made. So by the way, this deadlock can be explained by my classmate because it was stated further in Section 103 of the RCCP. Okay, number 7, a shareholder may withdraw and may ask the corporation to purchase his share. And generally, in ordinary corporation, the shareholder cannot withdraw and compel the corporation to purchase his share except as provided in Section 40 of the RCCP. So what is this What is this exceptions as provided in Section 40 of the RCCP? So going back uh, in Section 40 of the RCCP, those exceptions includes number one, in Section 40 of the RCCP, it authorizes the corporation to acquire their own shares provided that number one reason, the acquisition is for legitimate purpose or purposes, and number two reason is that the corporation has unrestricted return earnings in its book to cover the shares to be purchased or acquired. So those are some of the exceptions provided in Section 40 of the RCCP. Okay, we will proceed with the next slide. What are the differences between closed corporations and closely held corporations? Okay, a closely held corporation, also referred to a closed corporation, is a firm whose stock is held by a small number of people. It focuses more on the number of shareholders in the corporation at that particular time, indicating that they are few in numbers, while in a closed corporation, it emphasizes a determination on the part of the participants in the enterprise to keep outsiders from acquiring any interest in the business and may indicate that they have taken steps to accomplish that objective by shareholders' agreement on provisions in the Articles of Incorporation. So take note that these two, the closely held corporation and the closed corporation, are not the same, because a closely held corporation, it focus more on the number of shareholders, while in the closed corporation, it emphasizes a determination on the part of the participants to keep the outsiders from acquiring an interest in the business. Okay, we will proceed to the next slide. Okay, there is a problem. We have to answer together. Uh, I will read for you to understand. Classmates or graduates of Class 2000 of the University of Science and Technology of Southern Philippines, Claveria Satellite Campus, decided to form Gatas at Ibapa Incorporated. The principal purpose of which is to produce, package, and sell Carabao's milk. The Articles of Incorporation provided, among others, that the business of the corporation shall be managed by the stockholders of the corporation rather than by the board of directors, and restrict the transfer of shares to outsiders. One of the team classmates, Mr. Sakit Olo, disgruntled at the way the affairs of the corporation was being handled and demanded that all the 10 stockholders meet to elect directors. Meanwhile, Ms. Sakitian sued all the 10 classmates stockholders for damages for the violations of the Food and Drug Cosmetics regarding that a dead cockroach was found floating in the milk that she drank, the package of which pertains to the Gatas at Ibapa Incorporated. So here is the question. Can Mr. Sakit Olo demanded that a stockholder meeting be called in order to elect the board of director of the corporation? I will give you 1 minute to answer the question. Time start now. 30 seconds more to go. Ten seconds. 5 seconds. Time's up. So the answer is no. Gatas at Ibapa Incorporated is a closed corporation, and its articles of incorporation can provide that the business of the corporation be managed by the stockholders rather than by a board of directors. Thus, under Section 96 of the RCCP, the provisions that makes the stockholders managers precludes sakit or law from demanding that the stockholders meet in order to elect directors of the company. So, the answer is in negative. Gatas at Bapa is a closed corporation, and its articles of incorporation can provide that the business of the corporation can be managed by the stockholders rather than by a board of directors. So, by the way, a closed corporation stockholders is also the manager of the corporations. Thus, under Section 96 of the RCCP, the provision that makes stockholders managers precludes or prevent Mr. Sakit Olo from demanding that the stockholders meet in order to elect directors of the company. Okay. Question number 2. Does Ms. Sakit Tian have a cause of action against all the 10 classmates stockholders, although no negligence has been proven? Okay, I will give you also 1 minute. Time start now. Okay, 30 seconds more to go. 20 seconds. 5, and it's time is up. The answer is yes. Ms. Sakitian has cause of action against the stockholders. The stockholders, who are the managers of the corporation, cross corporation, are liable for the corporate torts. They are personally liable unless the corporation has obtained reasonably adequate liability insurance. Negligence need not to be proven to warrant the liability of a manufacturer of foodstuff under Article 2187 of the New Civil Code, because the liability under the same provision is in nature of strict liability. So in Article 2187 of the New Civil Code, it states that manufacturers and processors of foodstuff, drinks, toilet articles, and similar goods shall be liable for death or injuries caused by any noxious or harmful substances used although no contractual relation exists between them and the consumers. So in that provision, the nature is in of strict liability. So there is no escape liability here. So misakit yan as cause of action against the stockholders of the corporation. Okay? That concludes my report. Thank you once again and good evening.
Good evening, everyone. Tonight we're going to talk about Section 96, or the Articles of Incorporation. The Articles of Incorporation of a closed corporation may provide for 1. A classification of shares or rights, the qualifications for owning or holding the same, and restrictions on their transfers subject to the provisions of the following section. 2. A classification of directors into one or more classes, each of whom may be voted for and elected solely by a particular class of stock. And 3rd, greater quorum or voting requirements in meetings of stockholders or directors than those provided in this code. The Articles of Incorporation of a closed corporation may provide that the business of the corporation shall be managed by the stockholders of the corporation rather than by a board of directors. So long as this provision continues in effect, no meeting of stockholders need be called to elect directors, provided that the stockholders of the corporation shall be deemed to be directors for the purpose of applying the provisions of this code, unless the context clearly requires otherwise, provided further that the stockholders of the corporation shall be subject to all liabilities of directors. The Articles of Incorporation may likewise provide that all officers or employees, or that specified officers or employees shall be elected or appointed by the stockholders instead of by the board of directors. In a closed corporation, its Articles of Incorporation must comply with the requirements of Section 13 of the Revised Corporation Code and must contain the three requisites of a closed corporation as expressed in Section 95 of the Revised Corporation Code of the Philippines as mentioned earlier. In case the Articles of Incorporation provide that the business of the corporation shall be managed by the stockholders rather than by a board of directors, no meeting of stockholders need be called to elect directors. In such case, the stockholders of the corporation shall be deemed to be directors for the purpose of applying the provisions of the Revised Corporation Code, unless the context clearly requires otherwise. In case the corporation is management by stockholders, they shall be subject to all liabilities of directors. However, it shall be noted that nowhere in this provision do we find any inference that stockholders of a closed corporation are automatically liable for corporate debts and obligations. In fact, the limited liability of stockholders still applies to stockholders of closed corporations. The following are the effects of stockholders as managers. 1. There's no longer need to elect directors. 2. Stockholders shall be deemed the directors. 3. Stockholders shall have the same liabilities as directors. 4th, to the extent that the stockholders are actively engaged in the management or operations of the business and affairs of a closed corporation, the stockholders shall be held to strict fiduciary duties to each other and among themselves. 5. Stockholders shall be personally liable for corporate torts unless the corporation has obtained reasonably adequate liability insurance. Our next topic is Section 97, Validity of Restrictions on Transfer of Shares. Restrictions on the right to transfer shares must appear in the Articles of Incorporation, in the bylaws, as well as in the Certificate of Stock, Otherwise, the same shall not be binding on any purchaser in good faith. Said restrictions shall not be more onerous than granting the existing stockholders or the corporation the option to purchase the shares of the transferring stockholder with such reasonable terms, conditions, or period stated. If, upon the expiration of said period, the existing stockholders or the corporation fails to exercise the option to purchase, the transferring stockholder may sell their shares to any third person. The following are the validity of restrictions. Again, restrictions on the right to transfer shares must appear in the Articles of Incorporation, in the bylaws, and in the Certificate of Stock. Restrictions must appear in all three documents, otherwise the same shall not be binding on any purchaser in good faith. The restrictions on transfer of shares shall not be more onerous than granting the existing stockholders or the corporation the option to purchase the shares of the transferring stockholder with such reasonable terms, conditions, or periods stated. Restriction on transfers is in the nature of a right of first refusal in favor of the existing stockholders or the corporation. However, it can be waived upon the expiration of the period to exercise the option, and the transferring stockholder may sell his shares to any third person. Any transfer of shares should not result in the corporation having stockholders exceeding the maximum number allowed in the Articles of Incorporation and the Revised Corporation Code. Section 98. Effects of issuance or transfer of stock in breach of qualifying conditions. A. If a stock of a closed corporation is issued or transferred to any person who is not eligible to be a holder thereof under any provision of the Articles of Incorporation, and if the certificate for such stock conspicuously shows the qualifications of the persons entitled to be holders of record thereof, such person is conclusively presumed to have notice of the fact of the ineligibility to be a stockholder. If the Articles of Incorporation of a closed corporation states the number of persons not exceeding 20 who are entitled to be stockholders of record, and if the certificate for such stock conspicuously states such number, and the issuance or transfer of stock to any person would cause the stock to be held by more than such number of persons, the person to whom such stock is issued or transferred is conclusively presumed to have notice of this fact. C. If a stock certificate of a closed corporation conspicuously shows a restriction on transfer of the corporation stock, and the transfer acquires the stock in violation of such restriction, the transfer is conclusively presumed to have notice of the fact that the stock was acquired in violation of the restriction. D. Whenever a person to whom stock of a closed corporation has been issued or transferred has or is conclusively presumed under this section to have notice of 1. The person's ineligibility to be a stockholder of the corporation, or 2. That the transfer of stock would cause the stock of the corporation to be held by more than the number of persons permitted under its Articles of Incorporation, or 3. That the transfer violates a restriction on transfer of stock and the corporation may, at its option, refuse to register the transfer in the name of the transferee. E. The provisions of subsection D shall not be applicable if the transfer of stock, though contrary to subsections A, B, or C, has been consented to by all the stockholders of the closed corporation, or if the closed corporation has amended its Articles of Incorporation in accordance with this title. F. The term transfer as used in this section is not limited to a transfer for value. G. The provisions of this section shall not impair any right which the transferee may have to either rescind the transfer or recover the stock under any express or implied warranty. It shall be noted that actual absence of knowledge on the part of the transferee will not free him from the mandatory restrictions. It is clear from Section 98 that good faith is not a defense because there is a conclusive presumption of knowledge of the restrictions as provided in the Articles of Incorporation and stock certificates. Section 98 provides that the transfer in violation of the restrictions may still be registered in the books of the corporation in the following cases. 1. If all the shareholders consent. 2. If the Articles of Incorporation were duly amended. However, it shall be noted that in both cases, the corporation will no longer be a closed corporation if the conditions for its existence are not present, as in the case where the transfer results in the presence of more than 20 shareholders.
To continue on, closed corporations, let's proceed to Section 99, which is all about agreements by stockholders. Now, there are three types of agreements among stockholders which is allowed by the revised Corporation Code of the Philippines, and these are the following. Number one, the pre-incorporation agreement, which is found in paragraph A of Section 99. Number two, the voting agreement, which can be found in paragraph B of Section 99. And number three, the agreement on the conduct of corporate business and affairs, which can be found in paragraph C, D, and E in the same section. Section 99 states that this is all about agreements by stockholders. So the first paragraph, paragraph A, is actually a pre-incorporation agreement, which states agreements duly signed and executed by and among all stockholders before the formation and organization of a closed corporation shall survive the incorporation and shall continue to be valid and binding between such stockholders if such be their intent, to the extent that such agreements are consistent with the articles of incorporation, irrespective of where the provisions of such agreements are contained, except those required by this title to be embodied in said articles of incorporation. So, meaning the pre-incorporation agreement here, stated in Section A, is all about the agreements that were stipulated prior to the incorporation of the corporation. So, before they were even lawfully, officially created through the issuance of the SEC or Securities and Exchange Commission certification of incorporation, these agreements are already existing. So those incorporators have already agreed upon these stipulations, and then they continue on upon incorporation and shall be valid between the stockholders. So here, it is also very important that the intent of the stockholders here are consistent with the AOI or the Articles of Incorporation. And of course, otherwise, if those are not provided for in the Articles of Incorporation, then perhaps they cannot be binding and they cannot be valid any longer. So again, number one, the pre-incorporation agreement. Second is the voting agreement, which can be found on Section 99, paragraph B, which states that a written agreement signed by two or more stockholders may provide that in exercising any voting right, the shares held by them shall be voted as provided or as agreed, or in accordance with a procedure agreed upon by them. So this voting agreement is, of course, number one, the requisite is it's a written agreement. Number two requisite is that it should be signed by two or more stockholders. And the third agreement, that it provides the exercise of the voting right, any voting right. And that the shares, number four, held by them shall be voted as provided or as agreed, or in accordance with a procedure agreed upon by them. So we have to also consider what are the voting rights of the stockholders by law, by operation of law, and also the voting rights of stockholders in a closed corporation based on the voting agreement as agreed upon by the stockholders themselves. So that's Section 99, paragraph B. Section 99, paragraph C, D, and E this time refers to the agreement on the conduct of corporate business and affairs, particularly in a closed corporation, because as you already know, if you are in a corporation, there are different operational activities that needed to be done on a daily basis. Definitely. And letter C here states that no provision in a written agreement signed by the stockholders relating to any phase of the corporate affairs shall be invalidated between the parties on the ground that its effect is to make them partners amongst themselves. Well, it has been oftenly opined that closed corporations are a little more than incorporated partnerships because it's so closely knit and there is exclusivity as to who are the shareholders and who themselves become the directors, the officers, or even the corporate employees of the closed corporation. So in here in letter C, so no provision in a written agreement, so there cannot be any written agreement between the stockholders that they have signed, which is in particularity with the corporate affairs, such that if there is such written agreement, it will, invalidate some of the previous agreements in the effect that they become partners just amongst themselves. Because still, as a corporation, they are still bound by the bylaws and still bound by the articles of incorporation. So they cannot make or create any other agreements that are invalidating also what's already stated in the bylaws and in the articles of incorporation. Moving on to section 99 and paragraph D, which states that a written agreement among some or all of the stockholders in a closed corporation shall not be invalidated on the ground that it relates to the conduct of the business and affairs of the corporation as to restrict or interfere with the discretion or powers of the board of directors, provided that such agreement shall impose on the stockholders who are parties thereto the liabilities for managerial acts imposed on directors by this code. So, therefore, again, also relating to letter C, now when it comes to the conduct of the corporate or business affairs, particularly on the operational side or on day-to-day basis and decision making, is really the concern here, particularly of the managerial acts naman. So, no agreement can be made among some or any or all of the stockholders in this such close-knit corporation shall be invalidated on the ground that it relates to the conduct of the business and affairs of the corporation. So you cannot restrict or interfere with the discretion of the board because there is still a set of board of directors for a closed corporation. For as long as such agreement shall impose on the stockholders who are parties to such agreement the liabilities for managerial acts. So if there are managerial acts that may incur liabilities, and based on the code, which is the revised corporate code of the Philippines, they then shall be liable for such managerial acts if there are in cases of injury or damages. So again, this section 99 paragraph D refers to those conducts, therefore, of particular people who may hold also managerial acts or managerial positions in the closed corporation. Moving on to paragraph E. An agreement also providing that stockholders actively engaged in the management or operation of the business and affairs of a closed corporation shall be held to strict fiduciary duties to each other and among themselves. The stockholder shall be personally liable for corporate torts unless the corporation has obtained reasonably adequate liability insurance. So again, let me read that statement, the last sentence. The stockholder shall be personally liable for corporate torts unless the corporation has obtained reasonably adequate liability insurance. So, it does not automatically hold the stockholders themselves in a closed corporation personally liable for corporate torts if the corporation has already an existing adequate liability insurance to cover for the injuries, the damages caused or by the torts, the corporate torts, no? So it's very important because that proviso actually gives a sort of disclaimer and shields also the stockholders from having to be personally liable for the corporate torts, meaning using their own personal money and effects and even property in order to answer for the liabilities of the corporate tort. And again, in terms of fiduciary duties to each other, because it is a closely knit and a very exclusive corporation, it is therefore expected of them to have trust and confidence in each other. And at the same time, as a stockholder, especially if you're also a corporate officer or a director of such close corporation, it is also important for you to exercise due diligence and to be worthy of the trust and confidence that is given to you by the rest of the stockholders and other corporate officers as well. Now, let me reiterate the differences between closed corporation and ordinary corporations with respect and with highlights on the difference between closed and ordinary corporations on the fact that the closed corporation may be managed directly by the stockholders, because this is in particularity with Section 99, paragraphs A to E, as the stockholders being managers or as managers of the closed corporation, because in ordinary corporations, it is usually managed by a board of directors and not by the stockholders. However, such board of directors may be coming or should be coming from the stockholders, and such board of directors may elect amongst themselves who will be their specific corporate officers, from the president, vice president, corporate secretary, corporate treasurer, etc. If there are other officers or offices that are also indicated in the bylaws or the articles of incorporation. Now, this case of Sergio F. Nagiat versus National Labor Relations Commission, GR number 116123, dated March 13, 1987, is in particularity, or in particularity with Section 99 of the Corporation Code on closed corporation. Because here, in the case here, there is a petitioner, CFTI, which held a concessionaire's contract with the Army Air Force Exchange Services, or what we call a AFES, for the operation of taxi services in Clark Air Base then. Now, this Mr. Sergio F. Nagiat was the president of CFTI, which is a corporation, which is a family-owned and closed corporation, while Anthony T. Nagiat was its vice president. Like Sergio F. Nagiat Enterprises Incorporated, the or what we call the Nagiat Enterprises, which is a trading firm, it was a family-owned corporation. Now, this incident on the phase out of the U.S. military bases in the Philippines, which did not spare Clark Air Base, actually resulted to the dissolution of the AAFES, or the Army Air Force Exchange Services. And so the services of the individual respondents here were officially terminated. The AAFES, Taxi Drivers Association, or which we will call here the Drivers Union, through its local president, Eduardo Castillo, and CFTI, held negotiations as regards reparation benefits that should be awarded in favor of the drivers. And the individual respondents herein filed a complaint later on against Sergio F. Nagiat for the payment of the separation pay due to the termination or the phase out. Now, the private respondents failed to substantiate that their claim that Nagiat Enterprises managed, supervised, and controlled their employment. As it appears that they were really confused with the personalities of Sergio F. Nagiat as an individual who was the president of CFTI and Sergio F. Nagiat Enterprises, which is the corporation, as a separate corporate entity with a separate business. They presumed that Sergio F. Nagiat, who was at the same time a stockholder and director 27 of Sergio F. Nagiat Enterprises Incorporated, was managing and controlling the taxi business on behalf of the latter. A closer scrutiny and analysis of the records, however, evidenced the truth of the matter, that Sergio F. Nagiat, in supervising the taxi drivers and determining their employment terms, was rather carrying out his responsibilities as president of CFTI. Hence, Nagiat Enterprises as a separate corporation does not appear to be involved at all in the taxi business. And the issue here was whether or not a company president should be held solidarily liable by not paying proper separation pays to his or her employees. So again, this is as the corporation was a closed corporation, so therefore if the company president who was also a shareholder or stockholder of the corporation can be made to be liable for the damages and not paying the separation fees of the employees. So the ruling of the court here is that the responsible officer of an employer corporation can be held personally, not to say even criminally, liable for non-payment of back wages, as it is the policy of the law. And Sergio F. Nagiat admittedly was the president of CFTI who actively managed the business. Thus, applying the rule in AC Ransom case, he falls within the meaning of an employer as contemplated by the Labor Code, who may be held jointly and severally liable for the obligations of the corporation to its dismissed employees. Also, the petitioners considered that both CFTI and Nagiat Enterprises were close family corporations owned by the Nagiat family. And in quoting section 100 or 99 of the revised corporation code, paragraph 5, to the extent that the stockholders are actively engaged in the management or operation of the business and affairs of a closed corporation, the stockholders shall be held to strict fiduciary duties to each other and among themselves. Said stockholders shall be personally liable for corporate torts unless the corporation has obtained reasonably adequate liability insurance. So it is important to remember the last sentence because in the ruling, the courts have found that nothing in the record show whether CFTI obtained a reasonably adequate liability insurance. Thus, what remains is to determine whether there was a corporate tort. And essentially, the court here also stated that tort consists in the violation of a right given or the omission of a duty imposed by law. Simply stated, tort is a breach of a legal duty. And Article 283 of the Labor Code mandates the employer to grant separation pay to employees in case of closure or cessation of operations or establishment, as in the happening of the taxi drivers in their cessation of their duties or undertaking not due to serious business losses or financial reverses, which is the condition obtaining at bar. Now, CFTI failed to comply with this law, imposed duty or obligation, and consequently, its stockholder, who was also actively engaged in the management or operation of the business, should be held personally liable. So this is, again, with regard to the last sentence of paragraph E, section 99 on agreements. Now, we must also remember that there are implications when stockholders become managers of a closed corporation. And the emphasis here is on the integration of ownership and management captures the idea that justifies the regulation of such closed corporations. So this is from the book of O'Neill's Closed Corporations. And these are the three main points to consider. That first, the unity of the decision-making and risk-bearing function. In here, if it is in one group, and it can sometimes avoid these costly agency problem of protecting the passive shareholders who need some method of monitoring the performance of the corporation's managers and ensuring that the management decisions are aligned with the shareholders' interests. So because your stockholders are also your managers or your directors, there is already unity of the decision making and risk bearing function because there's only a few of you, and you can decide among yourselves, and the risks that you have to delegate amongst yourselves can be a little bit on the lesser side. It's less risky, and the monitoring of your decisions can be a lot easier to track, right? And that's one of the advantages of having stockholders as managers. Now, secondly, there is also unity of management and investor functions. Now, in a closed corporation, you may take, or the stockholders or shareholders may take full advantage from this unity of the management and investor functions, because ideally, if the corporation is composed of persons who have all the time, all the ability, and the training necessary to make sound business decisions and sufficient wealth. So if they have these skills in order to make, or managerial skills, for example, in order to make the best and the soundest business decisions to make your company or your business flourish, and if they have sufficient wealth to invest and to bear the risks of the enterprise, then you won't have to ask for any other outsider investor to put in money and capital to your corporation or to buy stocks and shares to buy stocks in order for your corporation to keep rolling or keep itself going, right? Because there's already the unity of the management and investor functions in the person of the stockholders. Okay, and the third advantage here is on the emphasis of reasonable expectations. That may be due to the basis of having personal relations amongst the shareholders or stockholders themselves holding managerial positions. Because in corporations, especially or particularly in closed corporations, they are usually based on personal relationships and such. If you put a personal touch to it and it's very close-knit and there's exclusivity in it, there may be reasonable expectations that may arise on the part of those acquiring interest in the closed corporation. So, or those acquiring interest, of course, the stockholders, the shareholders. The reasonable expectations here, for example, or may include that the party's expectation that they will participate in the management of the business, or they can also be employed by the company. Of course, if, for instance, in a closed corporation, there are only 10 of you, or maybe even 6 of you. So it is quite reasonable for you as a shareholder or a stockholder to expect that, oh, I may make or take up managerial functions in the business. I may become one of its operation managers, or I may become one of the directors, and I can use my managerial skills or other corporate skills, decision-making skills for that matter, in order to help make the business flourish, in order to, make the business more profitable, for instance. So because of that personal relations as the basis for the corporate managerial aspects, there are reasonable expectations from coming off from the stockholders. Now, what are the effects if stockholders also hold positions as managers in a closed corporation? First of all, there's no necessity to elect directors because amongst yourselves, you can already, if it is also included in your bylaws and in your articles of incorporation, you only need to elect amongst yourselves who will be the president, the vice president, the corporate secretary, and the corporate treasurer. And if there are other added positions, then so be it, for as long as they are included in your bylaws and the articles of incorporation. Second, stockholders deemed as directors. So it is quite expected that if you are to have a closed corporation and it is just exclusively among a few number of persons, then any one of all of you could become directors as well or hold managerial positions. Thirdly, stockholders have the same liabilities as that of directors because basically because of the fiduciary relationship between all of the corporate stockholders, then it is expected that you will also share the same liabilities. Again, concerning the fact that Section 99 and paragraph E for that matter, or the fifth paragraph there for that matter, states also that the stockholders can be personally liable if there is no liability insurance already in place or sufficient liability insurance that can cover for any particular action of damages or injuries incurred out of or by corporate torts. Number 4, the stockholders' strict fiduciary duties. Yes, because as it is a close-knit and exclusive corporation and there are only a few of you, it is important for you to exercise due diligence and be worthy of the trust and confidence of your other co-shareholders or co-stockholders or within the corporation. Now, and lastly, well, stockholders' personal liability for corporate torts, unless there is adequate liability insurance. Yes, that is also indicated in Section 99, paragraph E, or fifth paragraph and the last sentence thereof. So it is very important that to note that if you are a corporate or closed corporation, you must also have a sufficient or an adequate liability insurance that can help to cover for your corporate torts if in case any corporate tort shall happen in the future in the course of the operations of the business. Otherwise, each of the shareholder or stockholder shall be personally liable, or all of them shall be personally liable for the corporate torts. And again, it is very important to take note that to the extent that the stockholders are actively engaged in the management and business and affairs of a closed corporation, the stockholders shall be held to strict fiduciary duties to each other and amongst themselves. So that is number 4 as an effect. Now, as to effect of the stockholders' agreement before and after the formation of the corporation, it must be important to note that stockholders' agreements before and after formation and organization of the corporation survive the incorporation and shall be valid and binding for as long as they are not inconsistent with the articles of incorporation. So, whatever pre-incorporation agreements and even after the formation, so during the organization itself of the corporation, those agreements are valid and binding for as long as they're also not inconsistent with the AOI or the articles of incorporation. And agreements made prior to incorporation require fairly literal performance. There must be an actual contractual relation. And given such relation, the pre-incorporators are promoters and may arrange agreements to form and manage the corporation. So with regard to prior to the incorporation or the pre-incorporation, if there are agreements made there, well, the construence of such agreements may be on a fairly literal construction and performance. So it is important to establish if there is or there was an actual contractual relation made prior to the incorporation. And as a pre-incorporator, you are also a promoter of the corporation. And you may also make arrangements in order to help find or gather investors and even to manage the corporation in the course of its operations for as long as the corporation still exists. And so these pre-incorporators may also form such agreements and arrangements even prior to the incorporation. So that's about it for section 99, paragraphs A to E. Thanks for watching. Let's proceed to section 100.
Close corporation, sections 100 to 103. Sec. 100. When a board meeting is unnecessary or improperly held, unless the bylaws provide otherwise, any action taken by the directors of a close corporation without a meeting called properly and with due notice shall nevertheless be deemed valuative. Before or after such action is taken, a written consent thereto is signed by all the directors, or b. all the stockholders have actual or implied knowledge of the action and make no prompt objection in writing, or c. the directors are accustomed to take informal action with the express or implied acquiescence of all the stockholders. D. all the directors have express or implied knowledge of the action in question and none of them makes a prompt objection in writing. An action within the corporate powers taken at a meeting held without proper call or notice is deemed ratified by a director who failed to attend, unless after having knowledge thereof, the director promptly files his written objection with the secretary of the corporation. Board meetings not necessary. The general rule requiring board meetings is still applicable to a close corporation with the exception of cases provided under Section 100. In any of the situations contemplated under Section 100 of the RCCP, a meeting of the board is not necessary to approve corporate transactions. In a case where the exercise of T right of redemption by one of the directors of a close corporation of a property that was sold in a public auction was considered binding on the close corporation, the court observed that the resolution of its board of directors to give the validity to an act of a director as provided by Section 100 of the RCCP was unnecessary. Sec. 101. Preemptive right in close corporations. The preemptive right of stockholders in close corporations shall extend to all stock to be issued, including reissuance of treasury shares, whether for money, property or personal services, or in payment of corporate debts, unless the articles of incorporation provide otherwise. Sec. 102. Amendment of Articles of Incorporation. Any amendment to the Articles of Incorporation which seeks to delete or remove any provision required by this title or to reduce a quorum or voting requirement stated in said Articles of Incorporation shall require the affirmative vote of at least 2/3 2/3 of the outstanding capital stock, whether with or without voting rights, or of such greater proportion of shares as may be specifically provided in the Articles of Incorporation for amending, deleting or removing any of the aforesaid provisions, and a meeting duly called for the purpose. Notes: the preemptive right of stockholders in a close corporation extends to both issued and unissued shares. Issued shares, in case of valid restrictions on the right to transfer shares, existing stockholders or the corporation has the option to purchase the shares of the transferring stockholder, if, upon the expiration of the prescribed period, the existing stockholders or the corporation fails to exercise the option to purchase, the transferring stockholder may sell their shares to any third person. Unissued shares. The preemptive right of stockholders in closed corporations shall extend to all stock to be issued, including reissuance of treasury shares, whether for money, property or personal services, or in payment of corporate debts, unless the articles of incorporation provide otherwise. The following table shows the subject of amendments in a closed corporation which are to delete or remove any provision in the articles of incorporation and to reduce a quorum or voting requirement, and the required number of votes, which is 2/3 of the outstanding capital stock, whether with or without voting rights, or of such greater proportion of shares as may be specifically provided in the articles of incorporation at a meeting duly called for the purpose. Sec. 103. Deadlocks. Notwithstanding any contrary provision in the closed corporation's articles of incorporation, bylaws, or stockholders' agreement, if the directors or stockholders are so divided on the management of the corporation's business and affairs that the votes required for a corporate action cannot be obtained, with the consequence that the business and affairs of the corporation can no longer be conducted to the advantage of the stockholders generally, the Commission, upon written petition by any stockholder, shall have the power to arbitrate the dispute. In the exercise of such power, the Commission shall have authority to make appropriate orders, such as a canceling or altering any provision contained in the articles of incorporation, bylaws, or any stockholders' agreement. B. Canceling, altering or enjoining a resolution or act of the corporation or its board of directors, stockholders, or officers. C. Directing or prohibiting any act of the corporation or its board of directors, stockholders, officers, or other persons party to the action. D. Requiring the purchase at their fair value of shares of any stockholder, either by the corporation regardless of the availability of unrestricted retained earnings in its books, or by the other stockholders. E. Appointing a provisional director. F. Dissolving the corporation, or G. Granting such other relief as the circumstances may warrant. A provisional director shall be an impartial person who is neither a stockholder nor a creditor of the corporation or any of its subsidiaries or affiliates, and whose further qualifications, if any, may be determined by the Commission. A provisional director is not a receiver of the corporation and does not have the title and powers of a custodian or receiver. A provisional director shall have all the rights and powers of a duly elected director, including the right to be notified of and to vote at meetings of directors until removed by order of the Commission or by all the stockholders. The compensation of the provisional director shall be determined by agreement between such director and the corporation, subject to approval of the Commission, which may fix the compensation absent an agreement or in the event of disagreement between the provisional director and the corporation. Notes: there is a deadlock when the directors or stockholders are so divided respecting the management of the corporation's business and affairs that the votes required for any corporate action cannot be obtained, with the consequence that the business and affairs of the corporation can no longer be conducted to the advantage of the stockholders generally. This covers not only cases where the votes of two contending groups are equal, but also cases when the required vote cannot be obtained because of the division in the corporation. For instance, if any decision requires approval of 75% of the outstanding capital and the minority group owns 40% of the outstanding capital, decisions cannot be made or the stockholders if the minority will oppose any proposal of the majority. In such cases, the Securities and Exchange Commission, upon written petition by any stockholder, shall have the power to arbitrate the dispute. Thank you for listening and good evening.
Good morning, everyone. I am Casan Ali. I'm Limbona Jr. From Group 2, and I'll be talking about Article 104 of the Revised Corporation Code of the Philippines, or withdrawal of stockholder or dissolution. So, Article 104 provides for the remedies of a stockholder, which is to compel a corporation to buy his share and to compel the dissolution of the corporation. Now, to explain further, the first option is to compel the corporation to purchase its shares. Basically, Article 104 provides that a stockholder may compel the corporation to purchase his share at their fair value, which shall not be less than their par or issued value, provided that the corporation has sufficient assets in its books to cover its debts and liabilities exclusive of capital stock. So this means that the option to compel the corporation to purchase his share is contingent on the fact that the corporation must have sufficient assets in its books to cover its debts and liabilities. The second is the option to compel the dissolution of the corporation. So there are a few things that must be noted. The In order for this option to be enacted, there must be a petition for the dissolution of the corporation, which first must be in writing and should be based on the following grounds. First, that the acts of directors, officers, or those in control of the corporation, which are illegal, fraudulent, dishonest, oppressive, or unfairly prejudicial to the corporation or any stockholder, or the second ground being whenever corporate assets are misapplied. And the third requirement is that the petition in writing must be submitted to the Securities and Exchange Commission. So this means that in order for the stockholder to avail of this option, which is to compel the dissolution of the corporation, he must abide by these requisites, which must be the petition must be in writing, it must be based on the grounds provided, and it must be submitted for the approval of the Securities and Exchange Commission. That's all. Thank you.
For the second question, Mr. A member of a board of directors of XYZ Corporation, a closed corporation, engaged the services of Mr. X to provide technical service to the corporation. No meeting was held to approve the contract with Mr. X. However, all directors signed the contract. Can the contract be questioned on the ground that there was no approval by the board in a meeting code for such purpose? The answer: no. The contract cannot be questioned on such ground. Section 100 of the Revised Corporation Code of the Philippines provides that any action by the directors of a closed corporation without a meeting shall nevertheless be deemed valid if, among other cases, before or after such action is taken, written consent of the action taken is signed by all the directors. In this case, all the directors signed the contract. Hence, the same partakes of the nature of a written consent that makes a meeting of directors no longer necessary. Question number 3. The stockholders of ABC Corporation, a corporation organized as a closed corporation, were sued by an employee, Mr. X, for separation pay. At that time, the stockholders are the ones managing the closed corporation. The stockholders do not dispute that the separation pay was unlawfully withheld. However, they invoke the doctrine of separate personality in support of their position that they are not liable. Are the stockholders liable? Answer: yes, the stockholders are liable. The fifth paragraph of Section 99 of the Revised Corporation Code of the Philippines specifically imposes personal liability upon stockholders who are actively managing or operating the business and the affairs of the corporation. This covers cases involving torts liability. Tort under Section 99 consists in the violation of a right given or the omission of a duty imposed by law. In this case, there was an omission of a duty to pay separation pay. Question number 4. Rafael inherited from his uncle 10,000 shares of Santa Ana Corporation, a closed corporation. The shares have a par value of 10 pesos per share. Rafael notified Santa Ana that he was selling his shares at 70 per share. There being no takers among the stockholders, Rafael sold the same to his cousin Vicente, who is not a stockholder, for 700,000 pesos. The corporate secretary refused to transfer the shares in Vicente's name in the corporate books because Alberto, one of the stockholders, opposed the transfer on the ground that the same violated the bylaws. Alberto offered to buy the shares at 12 pesos and 50 centavos per share, as fixed by the laws of a total price of 125,000 pesos only. While the bylaws of Santa Ana provides that the right of first refusal can be exercised at a price not exceeding 25% more than the par value of such shares, the Article of Incorporation simply provides that the stockholders of record shall have preferential right to purchase said shares. It is silent as to pricing. Is Rafael bound by the pricing proviso under the bylaws of Santa Ana Corporation? The answer: yes. In a closed corporation, the restriction as to the transfer of shares has to be stated, annotated, in the Articles of Incorporation, the bylaws, and the certificate of stocks. This serves as notice to the person dealing with such shares, like Rafael in this case. With such notice, he is bound by the pricing stated in the bylaws. For the last question, Robert, Ray, and Ben executed a joint venture agreement to form a closed corporation under the Corporation Code, the outstanding capital of which the three of them would equally own. They also provided therein that any corporate act would need the vote of 70% of the outstanding capital stock. The terms of the agreement were accordingly implemented, and the corresponding closed corporation was incorporated. After 3 years, Robert, Ray, and Ben could not agree on the business in which to invest the funds of the corporation. Robert wants the deadlock broken. What are the remedies available to Robert under the revised Corporation Code to break the deadlock? Explain. For the answer, Robert can petition the Securities and Exchange Commission to arbitrate the dispute under Section 103 of the Revised Corporation Code of the Philippines if the directors or stockholders are so divided respecting the management of the corporation's business and affairs that the votes required for any corporate action cannot be obtained, with the consequence that the business and affairs of the corporation can no longer be conducted to the advantage of the stockholder. The Securities and Exchange Commission shall have the power to arbitrate the dispute. That's the end for my report. Thank you for listening.